Hello and welcome to our webinar, Holding Kleptocrats to Account, Redirecting Frozen Assets, and the International Anti-Corruption Court. I'm Susan Harada and I'm your moderator for today. The organizations that are bringing you this webinar are the World Refugee and Migration Council, which works toward a new vision for global cooperation to respond to refugees, and its partner QSO International, which is dedicated to eradicating poverty and inequality, as well as, of course, Integrity Initiatives International, an organization focused on strengthening enforcement of criminal laws against corrupt leaders or kleptocrats. I'm joined by 7 distinguished panelists, and I'm going to give you a little thumbnail sketch of each of them. Please know that their full and distinguished bios are on the council website, so let's meet them right now. Lloyd Axworthy, the chair of the World Refugee and Migration Council. Michael Camilleri, director of the Peter D. Bell Rule of Law program at the Inter-American Dialogue. Ángeles Estrada, the executive director of the Transparency and Anti-Corruption Initiative at the Monterrey Institute of Technology. Ratna, Omidvar, an independent senator in the Canadian Senate. Allan, a distinguished advisor for the World Refugee and Migration Council. Mark L. Wolf, the chair of Integrity Initiatives International. And we hope to be joined by Iegor Soboliev, a former member of the Ukraine Parliament, who will, as I said, hopefully join us in a moment. So to those of you joining us as members of the audience, we won't be able to see you or hear you during this webinar, but that doesn't mean we don't want to hear from you. If you have any questions, please add it to the Q&A box at the bottom of your screen, and we hope to get to your questions before our session ends. So we are on a very tight timeline today. Let's get right to it. You will likely be familiar with the term grand corruption. It's used to describe thievery on a massive scale, when a country's leaders and their collaborators steal money intended for the public good for their own personal gain. Grand corruption is a global problem. It happens in rich and poor countries alike. Our program today explores 2 different but related strategies to detect, deter, and punish grand corruption. The first calls for a new international court to go after dishonest officials who would otherwise operate with impunity in their own countries because they can block local police or local judges from taking action, or because the local justice system is also corrupt. The second proposal would make possible the confiscation of stolen assets that are stashed abroad by corrupt foreign nationals, and it would allow a country where the assets are parked to redirect the illicit funds to help people affected by the corrupt regime, particularly those forced to flee. So our first panel will flesh out these proposals, and Judge Mark Wolf, let's begin with you. You've been pushing for an international anti-corruption court, or IACC, for years. The pandemic and the related ramping up of aid transfers lends new urgency to that push. And we will be getting into the details of the pandemic aid issue a little later. The main point now is that when you talk about grand corruption, you're talking about massive amounts of money being siphoned off for private gain. Is that right?
Susan, thank you. That is correct. The World Bank estimates that 5% or more of global GDP is lost to corruption each year, including grand corruption. In some countries like Mexico, it's estimated to be more than 10%. But while these numbers, more than 10 times is lost to corruption than is given in foreign aid to developing countries every year. These are staggering sums. I think it's important to realize, though, that corruption generally and grand corruption, particularly the abuse of public office for private gain by a nation's leaders, are not victimless crimes. In 2014, the High Commissioner for Human Rights rightly said that corruption kills. The amount lost to corruption every year would be enough to feed the world's hungry 80 times over. Before the COVID pandemic, it was estimated that 10 to 25% of the trillions spent on healthcare around the world was lost to corruption. And if that could be recovered, universal healthcare could be provided by 2030. And there's an estimated 140,000 children die each year as a result of corruption.
So there's a solid case for an IACC, just in terms of what's at stake here. But sovereignty is always a consideration when it comes to setting up global bodies. With that in mind, how would you propose setting up this court to ensure there's cooperation?
Well, the court, it's important to realize that this corruption doesn't exist because of a lack of laws, particularly grand corruption. 187 countries are parties to the UN Convention Against Corruption. They all have laws against extortion and bribery and money laundering, as you said, but they don't enforce them against their nation's leaders because those kleptocrats control the police, the prosecutors, and the courts. So the International Anti-Corruption Court would be a forum for enforcing existing domestic laws or international counterparts against kleptocrats and their collaborators. It would operate on a principle of complementarity. So only if a country was unwilling or unable to prosecute its leaders would they be prosecuted in this court. There are many countries like Russia, for example, that are unwilling. The International Consortium of Investigative Journalists showed that Putin has laundered enormous amounts of money, $200 million at least, through close associates, and much of it into Switzerland. Switzerland might very well join this International Anti-Corruption Court. If Russia didn't, Putin could be prosecuted in the IACC for money laundering in Switzerland if the Swiss, for geopolitical or other reasons, didn't want to prosecute him. There are countries around the world, Mexico, Slovakia, Ukraine, Malaysia, that have swept corrupt parties and officials, high officials, out of office recently. They're very good candidates to join this court, and a coalition is emerging for the creation of the court and to advocate for that in connection with the UN special session on corruption next year. We very much hope that Canada will, with regard to the International Anti-Corruption Court, as it has with so many other human rights and international criminal justice issues, be a leader in this effort.
Okay, thank you, Judge. I'd like to draw in Senator Ratna Omidvar now on the subject of Canada. You are a champion of the proposal to redirect frozen assets. Can you walk us through how that initiative would work?
Thank you, Susan, and thank you for hosting this webinar. Let me start with the people who this legislation is aimed at. So on the one hand, we have close to 70 million internationally displaced people and refugees whose lives who will be deprived of safety and security, not just for the moment, but as research tells us, possibly for many decades. Many of these internationally displaced refugees find themselves in receiving countries such as Bangladesh, Jordan, Uganda, and Colombia. On the other side, we have the kleptocrats. You know, Susan, you spoke about grand corruption at a grand scale, and this is at display in places like Myanmar, the generals in Myanmar, who through their corruption and misgovernance have driven hordes of Rohingya refugees into Bangladesh. The same is true for South Sudan and the refugee inflow to Uganda, and the same for Venezuela, which through its political context and other reasons has created a massive flow of refugees into Colombia. So this legislation will proposes to seize the assets that have been located in a country like Canada by the kleptocrats for safekeeping. We already have sanctioned regimes in Canada and other places in the world where these assets are frozen. This legislation emancipates, so to say, the the frozen assets, seizes them, and redeploys them back to help and serve the people who have been displaced. It will be done through a court order in Canada to ensure full transparency and due process. I imagine that if this legislation is passed, it would achieve a number of objectives. One, and this is really important, hold kleptocrats to account in a different way than what's Judge Wolf has proposed. That's a proposal that requires international, multinational cooperation. The proposal that Canada will, I hope, be debating soon is dependent on Canada itself and can therefore magnify by traveling from jurisdiction to jurisdiction, just as the Magnitsky Act has expressed itself differently in different parts of the world. But
Can you,
also,
sorry to interrupt, I'm wondering if you could just briefly explain the Magnitsky Act for us.
So the Magnitsky Act freezes the assets of corrupt foreign officials. These officials are put on a list in Canada by our financial oversight institutions called FinTrack. And once those officials are put on the list, the banks in Canada who hold their assets are legally obliged to freeze the assets. So these assets are held in those bank accounts. Similar legislation is in force in the United States and in other parts of the world. We understand that the EU will likely also adopt Magnitsky type legislation in the coming year as Germany occupies the presidency. So there is a foundation, so to say, to leap off. And I like to describe this legislation, this proposal that comes from the World Refugee and Migration Council as Magnitsky Plus. Someone has even said it's Magnitsky on steroids.
Right.
Call it what you may, it makes the point. And it
now
has...
The sovereignty issue applies here as well. So most of the stolen money originates in the global south, and it belongs to the people of the country of origin, not to the global community, or in the case of your initiative, to Canadian courts. So how do you answer to the criticism that telling other nations how to use their money smacks of imperialism?
Thank you. I'm actually very sensitive to that question. I was born in post-colonial India and have experienced some of that, the legacy of colonialism. To begin with, one of the first principles of the World Refugee and Migration Council, which I was a counselor, which I'm still a counselor with, is not to do for refugees, but to do with refugees. And I will point out that our membership was drawn from all parts of the world, including receiving countries from Jordan, Uganda, Colombia, and other places. Secondly, I would sort of point out the relevancy of this proposal to the Global South, Susan, that you mentioned. From estimates, it is estimated that roughly $50 billion worth of illicit money flow out of Africa through corruption. This is almost twice the amount that is received, 50 billion, sorry, twice the amount that is received in overseas development aid. The principals of the World Refugee Council have spoken and have met with members of the African Union, and their interest in this is clear because some of this money could well be located in financial institutions in Africa itself, like Kenya, for example. So this proposal will work not just for Canada, but for countries in the global south, in the global north, and I'm certainly hoping that it picks up steam and gets adapted from country to country. And finally, the most important point against the argument, against the charge of colonialism, is that who is this money going to? It is going to the people of that country. It was stolen from the people of that country. It does not necessarily go back to the governments of those countries because they may not be the right distribution point for various reasons, but it will go back to the people of the country.
Thank you. I'd like to draw in Lloyd Axworthy now. Lloyd, how do these two initiatives as laid out by Judge Wolf and Senator Omidvar complement each other? wait till we unmute.
Oh,
I think we're having some muting issues. Lloyd, we still need to turn your microphone on there. No, we're still not hearing you. While we get that sorted out. Oh, no. While we get that sorted out, I'd like to widen the perspective a little, and we'll revisit that question in a moment. But first of all, let's go to Ángeles Estrada. Mexico's currently dealing with the case of Emilio Lozoya, who's a former minister and the former head of the Mexican oil company Pemex. You have made the point that the Lozoya case is a perfect illustration of why an IACC would be important for a country like Mexico. Can you explain that?
Thank you, Susan. Yes, so thank you to Integrity Initiatives International and the World Refugee and Migration Council for the invitation. Thank you also to everyone that is watching us and listening us. So, well, grand corruption, as Robert Rodberg mentions in his most recent book, is the large-scale theft of state privileges and opportunities for private gain. This is an endemic problem in many countries, and Mexico is not an exception. In Mexico, we have had for many decades the flourishment of complex corruption networks growing under the impunity generated by high-rank state authorities that have the power to undermine or even to eliminate completely any possible administrative or criminal investigation and judicial trial to punish the corruption committed by them or by their close colleagues, friends, and family. In Mexico, we have reached such level of corruption and impunity that public indignation has peaked, creating economic destabilization and unfortunately letting emerge a populist government that continuously misuses this situation to create social division and confrontation. But the real issue is if this social, political, and economic destabilization, along with the global crisis that the pandemic has created, will remain within the Mexican borders, or if it will affect our neighbors. In fact, in one of his articles, George Wolf says that corruption creates destabilization and that this creates serious danger for international peace and security that most countries have agreed to protect through the United Nations and other international institutions. So this is the main reason of why thus an international anti-corruption court is necessary and indispensable for facing a future that before COVID-19 looked shady and that right now looks honestly dark. I will return to this point later. So let me talk about the case of Emilio Lozoya. So Emilio Lozoya was the former head of Pemex, the Mexico's state oil company. He was part of Enrique Peña Nieto's cabinet, the former president of Mexico, supported by the political party that ruled Mexico for 70 years. In 2019, Lozoya fled the country when the administration of the new president, the current president, Andrés Manuel López Obrador, accused him of receiving bribes in connection with the purchase of agronitrogenados. It's a fertilizer plant abandoned 15 years ago. I mean, it was not even usable, but Lozoya, as the head of Pemex, decided to buy it for the modest amount of $274 million. Now, through the scrutination of a series of money transfers associated with the purchase of agronitrogenados, the authorities found a $3.6 million transfer to a shell company in Switzerland that was connected to Mr. Lozoya. And the money transfer to the shell company was done via a subsidiary of Odebrecht. And this transfer was apparently a bribe. Let's remember that some of the accused in the Odebrecht case admitted that they paid approximately $10.5 million in bribes to Mexican officials. Now, as the Odebrecht scandal unfolded in Latin America, former President Peña Nieto refused to bring any charges to Lozoya or to any of his colleagues. In this case of corruption, at least 5 high-ranked public servants, including former President Peña Nieto, has been named as part of this regional corruption network. Okay, so some weeks ago, Lozoya arrived in Mexico after agreed to his extradition from Spain. Upon arrival, Mexican doctors examined him to see if he was fine, and they found that he had anemia. Spanish authorities insisted that when he left Spain, he was completely healthy, but so he was sent to a private hospital, and in fact, his first hearing took place through a video call when he was at the hospital. So in the initial hearing, it was last week, it was held in private, which means that the public and the press won't have access to the hearings except for the WhatsApp messages that someone from the judiciary shared with the outside. Lozoya declared that he was not guilty of any crime. And regarding the purchase of agronitrogenados, he said that he was systematically intimidated, pressured, and instrumentalized by some of his former colleagues. He said he will denounce those who pressured him and that he will collaborate, of course, with the Mexican authorities. Another important piece of information is that in this case, Lozoya's mother and sister are also accused of money laundering for agronitrogenados. So as this telenovela unfolds, the Mexican society expect to see 5 things. First of all, Lozoya was not used or instrumentalized as he declared in his first hearing. He obtained a lot of money and houses for him and for his family as a reward for his corrupt services. Therefore, we expect to see some judicial consequence because of this. The second thing that we want to see is this was mentioned as an iconic case. Those were the exact words that the general attorney used to describe the case. Therefore, we expect complete transparency in Lozoya's trial. That would be the real iconic thing. The third one, $274 million were misused to buy agronitrogenados and to cover bribes and kickbacks that Odebrecht gave to Mexican authorities. We expect to recover at least some of those assets. The fourth one is that Lavallato case is the biggest case of corruption in the region. And in the countries that it happened, there are people in jail sentenced because of committing acts of corruption. Mexico was, until some months ago, the only country that was not even doing any kind of investigation. But still, Mexico is the only country that doesn't have any person in jail for this case. We expect to see at least some big fish behind bars.
Okay.
And the last one, and I think that this is the most important one, we expect that this case finally gives us, the society, the place of victims that we deserve to have in these cases of corruption. Right. To have less of what I mentioned, it would be seeing again the story of what we have seen since many years ago, impunity winning and society losing.
Right, thank you. This ties back actually to the question I had originally asked Lloyd. And I think, Lloyd, I'd like to circle back to you, if I could, with that question about how the 2 initiatives as laid out by Judge Wolf and Senator Omidvar complement each other. I think we're still having an issue with your microphone.
Okay, is that better?
Yes, here we go.
Oh, thank goodness. As you can see, I had to do a webinar on how to organize digital conversations, so I apologize for that. Let me say first that the panelists so far have outlined an overwhelming and serious risk that I think we face almost globally, that large amounts of resources are being purloined into personal and greedy purposes, and the consequences that thousands, maybe millions of people suffer as a result. The point that we've been emphasizing through the Refugee Migration Council is that we can identify these issues. What we have to identify is now solutions, which I think we've already heard a good, clear summary of. But then the third question is, how do you implement it? How do you take it so that it actually becomes a reality? And people can be skeptical in this age of COVID-19 when there's so much evidence of a shutting down, a shrinkage of international cooperation and activity, that this simply argues against it, particularly because so many of the kleptocrats are actually oftentimes heads of government or involved, as we've just heard from Mexico, closely aligned with governing parties. And therefore, the chance of that actually happening on a broad global scale right now is probably doubtful. But I think what Judge Wolf has put forward is an idea that a group of committed countries, along with the civil society groups, financial institutions, the various forms of aid and development organizations, have to come together to realize that while there's going to be an incredibly powerful requirement and demand for new investment in places that have been affected by the epidemic, as well as by climate, as well as by conflict, that if so much more of that money starts pouring in, and there has been no deterrent or accountability for its use, then you're going to have actually a mega amplification of what Susan called the grand corruption. And that's the purpose, I think, in the webinar. It's also a purpose of the council to demonstrate how you can put together a network using a model, what some of you might recall that we used in both the landmine treaty and then the International Criminal Court, to bring together interested parties and begin to working out from that. So in both those cases, we were able to get agreement and then bring it back into the UN system. And I think that's kind of a model that we should be considering.
Okay, we'll actually, thank you, Lloyd. We'll revisit that toward the end of this webinar. Let's hear a little bit more from the experience in other countries. I've noticed that Iegor Soboliev has been able to join us. So Iegor, Ukraine actually has a high anti-corruption court, which began operating in September 2019. With that national mechanism already in place, why would an international court be necessary?
Hello all, pleasure to take part in this discussion. Yesterday actually was an important decision of our domestic anti-corruption court. They sent to 8 years prison term one of the managers of state enterprise. The same results of this court, he is acting only 1 year. We do have against one corrupted judge and one corrupted local representative. What we see as a first results and first lessons of such court, I would say first result, this is really very efficient to have specialized institution that is responsible for struggling with the grand corruption with its own branches in prosecutor and investigating directions. We do have investigations and punishment that we haven't had for decades in Ukraine. I should remind that 6 years ago, we did have a bloody revolution against grand corruption. More than 100 people died. Then Russia invaded Ukraine, and I think the question, can leaders rob their own citizens, or they should be responsible, they should govern properly under the public control? I think this question is the main question behind Ukrainian-Russian conflict. And in this war, we lost more than 15,000 people already. And we do have more than 1 million displaced persons. And nobody knows when there will be the end. So this is extremely important and a real question of lives for many people, how to stop this grand corruption. And this, we do have another lesson, another result of this first year acting of specialized institutions. Corruption is international. All important cases here in Ukraine lead to another countries, starting from the case of Mr. Manafort, who is now in American prison. He was the main political aide of the President Yanukovych, who escaped to Russia after the Revolution of Dignity. Or we can move to our another very rich man, Mr. Firtash, who is now in Austria, is struggling against his deportation to the United States again, because here he is facing accusations against corruption in India. So this is our obvious and clear lesson. Corruption is international, and it is impossible to stop it, to, I would say, undermine it seriously without international tools. That's why I think Ukraine definitely will be among countries that will ask our neighbors in the world to establish international institutions like Judge Wolf proposes.
Thank you. Let's turn to the US right now briefly. Michael Camilleri, some proposals for holding kleptocrats accountable and returning stolen assets to their rightful owners require innovative solutions and legal reforms. Other efforts are possible with laws already on the books. And can you talk a little bit about the options that exist already in the US?
Hi, can you hear me?
Yes. Oh, briefly we did. Try again.
Can you hear me now?
Yeah.
All right, terrific. Sorry about that. So great to be with you all. Really want to thank the World Refugee Migration Council and III for the invitation to participate. Much of what I'm going to talk about actually is based on a seed that was sown in a collaboration between the Inter-American Dialogue and the World Refugee Council in 2018, looking at the Venezuelan refugee migration crisis. So it's great to renew the collaboration and also to share a virtual stage with Judge Wolf. So when it comes to holding kleptocrats accountable, at least in a financial sense, I think there are a number of relevant provisions of US law. They actually mirror, I think, quite closely what was described in terms of the situation in Canada. We also have a Global Magnitsky Act, as well as other statutes that allow our Treasury Department to seize, to freeze the assets of corrupt foreign officials, human rights abusers, and so on. This is often what you hear about when you hear of the US slapping sanctions on officials from Russia or Iran or North Korea, South Sudan, Venezuela, and so on. These are the authorities that are being applied. The statutes, as a general matter, do not allow the Department of Treasury to move from freezing assets to actually seizing and then disposing of them. So the legislation that the senator described in Canada that would allow kind of Magnitsky on steroids does not exist in the United States as things stand. However, and this is where I'd like to focus, our Department of Justice does have the authority to, through civil and criminal forfeiture cases, actually proceed to seize assets in these cases. In fact, in 2013, the Department of Justice created a kleptocracy asset recovery initiative with precisely this purpose. And given the centrality of the US financial system to global financial flows, it is often the case that illicit finance flows through the US system in some form or another, and gives the DOJ jurisdiction to pursue these illicit assets. And in fact, it has succeeded in recovering hundreds of millions of dollars stolen by kleptocrats in foreign countries. Now, this obviously
and repurposing or redirecting.
Well, that's precisely where I was going to go next, which is this obviously raises the question of then what happens with those assets that have been recovered. So this is more complex as a practical matter. I think as a legal matter, it's quite clear. The UN Convention on Corruption, which has been ratified by I think Judge Wolf said 180 or so countries, states that as a general principle, countries should provide the widest possible cooperation in returning the confiscated proceeds of corruption to their prior legitimate owners, and US policy and practice is reflective of that. The challenge has been mentioned is that in some cases you still have kleptocratic governments in charge in the places where the money was stolen from. And so, returning those assets can be quite straightforward in some cases, and it can be enormously complex and challenging in other cases. And the Department of Justice in the United States takes the position that assets should only be returned where there are guarantees they will benefit the people, where it can be done in an effective and transparent way. And what we've seen is that there is now kind of a body of practice on this, which is still being built, but nonetheless is extremely promising in terms of the creativity that's been brought to bear in some of these very challenging cases. In places like Nigeria and Kazakhstan, for example, where there were ongoing corruption concerns in terms of returning the recovered proceeds of corruption, there have been measures taken to kind of sequester those proceeds, those returned assets in dedicated funds, to direct them to specific programs or agreed objectives, empowering local civil society organizations to monitor the disbursement of the funds, and even in the case of Kazakhstan, setting up a dedicated foundation under World Bank auspices run by international nonprofit groups to return money through cash transfers and scholarships and other mechanisms directly to the people of that country, while essentially bypassing the government. So there is, I think, a really kind of interesting and to some extent promising set of case studies that we've been looking at closely and thinking about how it might apply in places like Venezuela, where some of these challenges are present, and that hopefully we can get into that as the conversations proceed.
Yes, thank you. That actually, we will return to Venezuela later. I would like to bring in Allan Rock right now, who can talk about one country where there is legislation similar to what the senator was talking about that allows for the confiscation of stolen assets. And perhaps Allan Rock, you can tell us how well that's been working.
Thank you, Susan. The country is Switzerland.
Sorry, Switzerland.
Yeah, and the Swiss adopted practices in the early part of the 2000s aimed at strengthening the reputation of their banking system, which is an important part of their economy. The practices that they adopted included going to court to ask for an order allowing them to confiscate frozen assets and return them, not to the corrupt government still in place in the country of origin, but to foundations, as Michael said, or to civil society, to use the money for the betterment of the population. So if you had a situation where the money which has been frozen in the Swiss bank account originated in a country which is still in the grip of a corrupt regime, obviously you don't want to send that money back there to be restolen. So they developed the practice of going to court, asking for an order to allow them to seize that money and give it to the International Red Cross or CARE International, or as the case may be. And in 2015, 2016, the Swiss codified those practices in legislation, which now expressly provides that where the government of Switzerland has these frozen assets in Switzerland and wants to return them, if it's unable to come to an agreement for their return, then the statute now formally provides that they can apply to court for an order authorizing confiscation and repurposing. We met with the people responsible for that legislation when we were in Geneva last year. And they talked about the great success they've enjoyed in applying it. Billions of dollars have been repatriated that way, not to the corrupt regime, but to third parties who are able to use the money for the benefit of the population. The Kazakhstan Foundation, I think, is one of the most significant examples. I should say that Switzerland is leading the way, and we looked very closely at its legislation in making our proposals for the World Refugee and Migration Council. But the Swiss themselves, when I met with the person responsible for drafting and advancing the legislation in Switzerland, told us that the model that we propose through the Foreign Asset Repurposing Act that Senator Omidvar put before the Senate is much preferable, simpler, more direct, clearer in its purpose and its process. So we think the approach we're recommending is based on the Swiss example, but learns from it and perhaps improves upon it. Let me just add quickly, there are other countries very interested in this proposal. The World Refugee and Migration Council has met with legislators in the United Kingdom and in Germany. And we met with the African Union in Addis Ababa last year. We met with the Council of the Organization of American States in Washington. There's a lot of interest in this proposal. People around the world can see the benefit of it. And so we're very hopeful that this can make a material difference in holding kleptocrats to account and using the proceeds where we can't return them to the government of the country in question, using them for the benefit of the population in an enlightened and effective way.
I'd like to ask you very briefly, if you will, to explain what kind of legal challenges legislation like this might face.
Well, I can speak for Canada. Obviously, the legislation would have to pass constitutional muster. Is it constitutional in two respects? First of all, does the confiscation of an asset in this way infringe on the guaranteed charter rights of those to whom the charter applies? And second, is it within federal jurisdiction? Because as a federation, Canada is constantly looking at the question how authority is distributed between the central government and the provincial governments. On the first question, our Charter of Rights and Freedoms does not guarantee property rights. And there's been one case already in the federal court which was relevant, although not directly on point, suggesting that the absence of property rights in the Charter of Rights and Freedoms means that the government's ability to freeze and deal with assets is unaffected by the Charter. On the question of the division of powers, I'm confident that when it comes to examining the role of the federal government in Canada to determine our foreign policy, including organizing affairs so as to provide relief to refugees and displaced persons through instruments available to the federal government, that will be found to be within federal jurisdiction. I should also say that the reason we adopted the process that's been recommended and reflected in the Senator's bill is that it makes the government go to court on notice to all interested parties. The government must make its case based on admissible evidence that these assets were improperly taken, that they're properly frozen in Canada, that they should not be returned to the incumbent government, and that here is a plan to use the assets for the benefit of the people of the country of origin, We suggest it should be for refugees and those displaced by the corrupt government. But the point is, the process we propose is open, transparent, under judicial supervision, with accountability for the government of Canada or whatever government's involved. And the court would have authority to monitor how the order is carried out. In other words, the person who's told to take the money and spend it for the benefit of the population of the country of origin would have to account for every penny, how it was spent, where it was spent, and it was spent in accordance with the court order. So there is a degree of accountability in all of this. And all these factors, we believe, would tend a court to conclude, if and when the legislation is challenged, that it is consistent with fundamental rights and ought to be upheld.
Thank you. Senator Omidvar, staying in the Canadian aspect of things, but you could branch out actually. Very briefly, why is it important to keep the focus on assisting refugees? I think you need to unmute your microphone.
Sorry, I too should go to Zoom school. Let me start by saying that corruption has many victims. Grand corruption has victims at a grand scale, if I may use that terminology. The intent of the legislation that I proposed, that was based on the proposals of the World Refugee and Migration Council, has forced displacement at its heart, mass forced displacement at its heart, because we're talking about 70 million people. So I believe it is really important to tie the corruption to the victims.
Okay, thank you. And I think we've got a weak internet connection there, but I would like to stay on that topic and go to Michael Camilleri, who can tell us a little bit about the situation in Venezuela and the refugees and why why it's so important to keep the focus on them.
Great, thank you. I think it's been said several times now that corruption is not a victimless crime, and Venezuela, I think, is a good example of that. I mean, just for a bit of context, over the past half century, there is no economy in the world that has collapsed as far and as fast as that of Venezuela. In the 5 years after Nicolás Maduro came to power in 2013, the economy shrunk something like 2/3. And the consequences of this are very predictable and visible in terms of poverty and hunger, and infant mortality and communicable diseases, but maybe most visibly in the exodus of over 5 million people, in addition to a lot of forced displacement within the country. But over 5 million people have actually fled Venezuela. So this was once the richest country in South America, and now Venezuelans survive with intermittent electricity and water shortages and food handouts and a public health system which is on the verge of collapse in the midst of a global pandemic. Now, the staggering thing about this is, as much as the scale is the cause. I mean, this was not a country afflicted by natural disaster or war. It was afflicted by grossly incompetent and greedy leadership over the course now of more than 2 decades. And corruption really is at the heart of that. So when we're looking at this historic economic contraction and the largest displacement crisis in the recent history of Latin America, corruption really is central to that story. And so, the logical question then becomes, can we somehow scratch back some of the potentially hundreds of billions of dollars that have been stolen from the Venezuelan people and apply that money to actually address the humanitarian emergency, either within the country and or the situation afflicting the migrants and refugees that have had to leave. And this is the question that we're looking very closely at in a report that will be released next month. There is currently, just in the United States, approximately $1.5 billion currently under scrutiny in cases working their way through the US justice system. Globally, a Venezuelan NGO, Transparencia Venezuela, estimates that $24 billion is under some sort of regulatory or legal scrutiny. And if even 10% of that money could be recovered and returned to the people of Venezuela, that would vastly outstrip the sum total of humanitarian assistance that's been provided by the international community to address the tragedy in Venezuela. So we are very focused on the mechanics of how that could happen in Venezuela. The politics are incredibly complicated, not just because you have a regime still in de facto control that is responsible for much of this corruption, but also because most of the West, including the US and Canada and the EU, recognize Juan Guaido as the legitimate leader, while Nicolas Maduro continues to exercise a de facto control. So, in terms of the authorities that you would work through or work around in terms of returning this money, even there's sort of a political impasse that is unlike anything we've dealt with in some of the other challenging cases I've mentioned. So we're looking at a few potential vehicles for doing this, working through international institutions, multilateral institutions, international charities. We think it can be done. And we think there's a moral imperative to do as much as possible to recover and to return this money to the Venezuelan people as quickly as possible, provided it can be done in an effective, transparent, and accountable way.
Okay, thank you. I know we mentioned at the beginning of this webinar that the pandemic has lent new urgency to doing something with these initiatives. I'd like to briefly hear from Mark Wolf about the situation globally. You have to turn on your microphone.
At the outset of the pandemic, Justice Richard Goldstone, a co-founder of Integrity Initiatives International, former chief prosecutor for the International Criminal Tribunal for the former Yugoslavia, and I and my colleague on the III board wrote an op-ed piece predicting that the pandemic would prove to be a bonanza for kleptocrats. Lloyd Axworthy and Allan wrote a comparable piece published in Canada. And unfortunately, the evidence is demonstrating that this is true, because money is urgently being distributed in large sums without even the usual ineffective safeguards. So, for example, we see now, and these are just a couple examples, the Bolivian health minister has been arrested for paying an intermediary millions too much for ventilators that didn't work. 3 governors of Brazil are under investigation for comparable conduct. And the prime minister of Bosnia's Muslim Croat Federation was recently arrested for paying a fruit processor 5 million euros for ventilators that don't work. This has, of course, tremendous human consequences, and something that needs to be dealt with and deterred, particularly.
And it is the human consequences that everyone keeps returning to here. We now have time for a few questions from our audience. We've had a lot of questions come in. Unfortunately, we may not be able to get to all of them, but let's start with Anila Noor, who is a refugee, who co-founded the Global Independent Refugee Women Leaders Network. I don't know whether we have her. Oh,
hello, can you hear me?
We can, and I should just let everyone know that we won't be able to see Anila, but yes, we will be able to hear her.
It's okay, no worries. Thank you, everyone. It's really very interesting and needed debate. I really thanks everyone and congratulations for taking this topic out. My concern is, like, being a refugee living in Europe, we see there's hardly any discussion or reliable system to change or bring accountable a person to the court, or to create some kind of success stories, how we can see naming and shaming trend. So it's really complicated, and people get away very easily, either they are from developing country or developed country, who make a fraud, who really creating corruption. So corruption is still becoming like a business. So how we can really shut out and target and really loudly, clearly highlight, indicate this kind of action and system. So this is my worries. There is no system and a lack of cooperation, and how we can work in solidarity to highlight even naming shaming things should be start right now. Thank you.
Judge Wolf, do you want to briefly take that one on? With your microphone on.
Certainly. We've heard today that the refugee crises around the world really do show the profound human consequences. And Integrity Initiatives International fully supports the proposals of the World Refugee and Migration Council to deal with this immediately. But it's impossible, I think, we can tell from what we've heard today, to deal with these problems adequately after they occur. Something has to be done to keep them from occurring. And this is why we need the International Anti-Corruption Court, not naming and shaming alone, not civil asset recovery, which isn't an effective deterrent. The fundamental premise of the criminal law is that people will be much worse off if they violate the law than if they don't. And as we've heard, right now, there's no credible threat that kleptocrats and their collaborators will be prosecuted, imprisoned, and removed from office. The IACC would create that credible threat. And it's important to recognize that in contrast to war crimes or crimes against humanity, which often are rooted in ethnic conflict or the passions of war, grand corruption is a crime of calculation. Kleptocrats calculate that if they misappropriate vast sums of money or take huge bribes, they won't be caught, they won't get prosecuted, and they won't get punished and removed from office, put in prison. So the IACC would create that credible threat that the laws that exist in their countries will be enforced against them. It will deter. It's also, the IACC could be a vehicle for recovering and repatriating stolen assets. When I issue an order, a sentence in a criminal, a fraud or corruption case, I order restitution or disgorgement, repayment. And significantly, although there's not time to develop it, the International Anti-Corruption Court could be a forum for a counterpart of what we have in the United States, the False Claims Act. Cases brought by whistleblowers in the name of the government,
Right.
which can recover hundreds of millions or billions of dollars, and that can be either repatriated to the country or used in the manner that the proposed Canadian legislation would have it used to ameliorate the plight of the victims.
Okay, thank you. We will move on to our next question from Devota Nue, who is a lawyer with the Refugee Law Project. I understand there she is.
Thank you. I had a question about what are the safety measures that the World Refugee and Migration Council have for whistleblowers? Thank you.
Okay, so I think we can ask Allan or Lloyd Axworthy to take that one on.
I'll speak to that. The legislation, there's legislation in Canada to protect whistleblowers in the workplace, government workplace. When it comes to whistleblowers and corruption internationally, I think much will depend on the laws of the country in question. But clearly, you do need to protect people who are coming forward with incriminating facts about criminal or quasi-criminal conduct and tipping off the authorities to behavior that's not in the public interest and could lead to discovering assets that have been purloined. So I think Devota has identified an aspect that must be addressed as we go forward internationally, trying to protect people who come forward with information of that kind.
Okay, thank you. We have a question from Alessandro Mater to all panelists. It says, or it's asking, it may sound naive to ask, but I think it's important to establish some kind of official reference to determine which governments and regimes are not to be trusted with frozen funds. Is there a blacklist that the UN or others have already adopted as basic reference how else to avoid arbitrary determinations that a government is corrupt? And I think we can throw that one first to Mark Wolf.
I actually think that Allan or Lloyd might be more authoritative on this. I'm not aware of a particular list, and these are, as Mike Camilleri referred to, extremely difficult questions, but there have been some successes. The UK has returned in way to several African countries money for building hospitals, for getting ambulances, for specific purposes with what were regarded as reasonable safeguards.
Right.
But
Okay.
Lloyd and Allan would probably be more authoritative on that one.
Thank you. Why don't we hear from Lloyd on it?
Sure. I think lists are kept in individual countries to the degree that they become sort of a pool at an international level is not particularly acknowledged right now. And I think that's one of the reasons for this webinar is to talk about what things have to happen to provide a foundational base so that actions on a court or on assets can actually begin to be applied, nowhere to go. I would mention this, it is an important kind of initiative undertaken by one of the NGOs in Washington who do forensic examination, you asking the old political science question, where's the money? And they're beginning to find through increasingly sophisticated means, being able to track money and to where it goes and who's holding it. So I think that part of the ambition in developing a comprehensive initiative is to begin doing that kind of tracking and that kind of shared information at a global level, because I think as Judge Wolf pointed out, you can't do this one by one. I mean, it's now become sort of a place where that money moves around in nanoseconds on the internet and can go into all kinds of strange places. And that's why an international approach has to be applied.
Okay, thank you. We have a question from Andrew Thompson. What involvement, if any, would the Security Council have with an international anti-corruption court? Would the Supreme Court be able to refer cases to the court like it can with the International Criminal Court? What measures could be taken to ensure the P5 couldn't use their veto to block cases from going before the court? And I think this is something Allan or Mark Wolf can answer.
Why don't I take the first crack at that? This raises the point that there are crucial details to be developed with regard to the International Anti-Corruption Court, and it would be very appealing if people on this webinar would express interest in participating in doing that. The International Criminal Court was established through the United Nations, and the Security Council can both refer cases against countries that haven't joined the court and essentially veto prosecutions, which has resulted in criticism, particularly the latter of the ICC. It's not clear whether the International Anti-Corruption Court will or should be created through the UN process and be comparable to the International Criminal Court with respect to the role of the Security Council. There is a 2021 special session on corruption. It's hoped that the International Anti-Corruption Court will advance through the UN process there. Colombia, among other countries, has urgently advocated that. But Lloyd Axworthy personifies the fact that it is possible to achieve important international goals outside the United Nations system. He was absolutely central, as almost all of you know, to the landmine ban treaty, which was created outside the UN system. And if that occurs, then the Security Council, with regard to the UN International Anti-Corruption Court, the Security Council wouldn't have the ability to distort, impact prosecutorial decisions the way it does in the International Criminal Court.
Susan,
and actually that leads nicely back to Lloyd Axworthy, who is going to pull a lot of these threads together for us. Lloyd, although he looks frozen right now. I don't know if you can hear me. What needs to happen next, just in terms of big picture? I'm not sure whether we still have him.
Well, I think I do. I see everybody else. I hope they see me and hear me. Just as a quick sort of conclusion, first let me talk about the money issue that's come through all these discussions. One of the other sort of real negatives on the ledger is that right now, the international humanitarian system, refugee displaced person systems is scrambling for funds. Only about 30–40% of pledges are being honored. And therefore, the vast number of people are being faced with restrictions and limitations on basic need support. With the epidemic coming, that becomes even more amplified. And thirdly, there's just been a recent report about the impact of climate change taking place in large numbers parts of the world, in which drought and famine and heat are going to, again, probably another 20, 30, 40 million people to be on the move. And there is no resources for that. And so one of the clear issues, being very kind of pragmatic about it, is to begin finding sources of money and finance to help meet these kinds of global demands. And I think that is part of it. The other point is what Judge Wolf said about the deterrent. I mean, right now, if you can put money in your piggy bank and nobody's going to come and snatch it from you, then you've got license. If, however, they know that they can be charged criminally and publicly and transparently, then I think there's a real deterrent effect. So my view, Susan, is that one of the things that governments have to start getting their head around is that the whole notion of international development aid must take a much broader scope than simply transferring funds from a government budget. We've just described how there are billions of dollars available that you could obtain through legal means. There are ways of deterring large amounts of money that are going to be transferred or given as development aid from going into the back pockets of the kleptos. So as a result, I think this is a time when we are going to reopen, I hope, a much more innovative view about how to get back to normal. Going back to normal is not what we need to do. We have to be going back to a new normal, a new set of orders and restrictions. And I would just sort of close with this. One of the reasons for this webinar is to begin to provide a public input. My experience, I'm working on things like the Landmine Treaty, the International Criminal Court. You have to have a public buy-in, a public support. And one of the things that we were able to do is to begin generating public demands on their own governments that they join in this kind of effort. And so that's one reason why I think the collaboration of the Integrity Initiative and the World Refugee Migration Council is that together we can begin to pool our networks and bring other networks into place so that the kind of coalition that Judge Wolf talked about could take place and maybe be something that would be an initiative that could be properly introduced in that UN assembly that takes place next spring.
Hello all, this is Jeff Staub from the World Refugee and Migration Council. Unfortunately, we've just lost our moderator, Susan Harada. Hopefully she'll join shortly. But we would like to just do a little bit of a summary before we close out the event. Hoping that Allan Rock, perhaps you could make a few notes and we'll thank everybody after that for participating, and I'll put up some information to share with our participants today.
Well, thank you, Jeff. Clearly, the ideas we're talking about here converge. We're talking about dealing with corruption and dealing with the proceeds of corruption for the benefit of the people who were deprived of the assets. And through legal and political efforts, by creating a new international court that will hold people to account in a meaningful way, that will instigate and supervise and carry out investigations with integrity and bring charges against those responsible and adjudicate those charges in accordance with due process and the rule of law. And at the same time, urging governments to adopt legislation which, in a transparent manner, will allow them to seize and repurpose ill-gotten gains right now sitting in the banks in those countries for the benefit of the most vulnerable who were hurt by the theft of those funds, those ideas converge in a sort of global approach to accountability in dealing with grand corruption for the benefit of the most vulnerable. So I think today, I hope we've brought attention to these concepts. We've developed some interest in the proposals, hopefully some support. We encourage everybody who's watched and listened today to provide us with your ideas and perspectives. How can these proposals be improved? And more than anything else, if you think we're going in the right direction, these proposals are worthwhile, then bring pressure to bear on the governments of your countries to support them, so that through political international action, we can address the scourge of corruption, we can assist refugees and the displaced, and we can bring justice to those who are stealing the money so badly needed by others. Thanks, Jeff.
Thank you, Allan. Thank you everyone for participating today. We got a lot of questions from the audience, and we're tried to answer as many as we could today. Be sure that we will follow up with you, and I put up some information on the screen here, which we'll also send to you by email, a few documents and website links that will give you additional information and help you understand better where we're going together on these proposals. There are 2 email addresses there. We'd very much like to hear from you, as Allan suggested, to know what your ideas are, to hear how you would like to address the problems and how you could get involved to support these things. Thank you everyone for participating. Thank you in particular to Integrity Initiatives International and to Judge Wolf for helping us to organize this webinar. We'll look forward to seeing you again and expect to hear from us very soon.
Thank you, Jeff.
Thanks, everybody.
Thanks, everybody.
Much appreciated.
Bye-bye.
Thank you.
Thank you.
Very much appreciated. Jeff, are you still on? Appears you are.